Generally, property managers should return funds within 35 days. Facts: a landlord and a property manager executed an AAR property management agreement on January 1, 2015. In June, the landlord and property manager mutually agreed to cancel the property management agreement. The landlord is making a demand to the property manager that all funds in the broker's trust account be given to the landlord immediately. The property manager knows there is an invoice that will be coming in that will need to be paid for services rendered by a contractor within the past few weeks. Issue: is a property manager entitled to hold the landlord's funds until all invoices have been paid before remitting the balance to the landlord? Answer: see discussion. Discussion. ARS. Par 32-2173C states, on termination of the property management agreement, the property management firm shall provide the owner with a final accounting of the property's financial status that includes at a minimum: 1. Within 5 days, a list of all tenant security obligations. 2. Within 35 days, reimbursement for all monies remaining in the property accounts maintained by the property management firm, except for monies needed for unpaid obligations incurred during the term of the property management agreement. 3. Within 75 days, a final accounts receivable and payable list. 4. Within 75 days, a final bank account reconciliation is required. Emphasis added. Therefore, the property manager should return all monies to the landlord within 35 days, except for the money the property manager estimates will be needed to pay the invoice. Maintenance man cannot perform. Move-in. Move-out inspections of rental property. Issue: at the time any tenant in the apartment building moves in or moves out, the property manager sends the maintenance man to handle the move-in or move-out inspection. The maintenance man is not a real estate licensee. Can the maintenance man perform the move-in or move-out inspections? Answer: probably not. ADRI Substantive Policy Statement 2005.04 specifies certain acts that can or cannot be performed by a non-licensee. One activity specifically not allowed by a non-licensee is perform a walk-through inspection. Therefore, the maintenance man is probably prohibited from conducting move-in or move-out inspections on a rental property. Management fees should not be charged. On sales tax. Facts: a property manager and property owner use the Arizona Realtors R Property Management Agreement, PMA. The property manager collects $2,500 in rent and an additional 1.65% in rental tax from the tenant. Issue: may the property manager charge a management fee based on the total amount collected, $12,841.25? Answer: no. Discussion. Pursuant to Section 5, page 4 of the PMA, management fees shall not be charged on sales tax. Note: as a best business practice, the property manager should enter the collected rent and tax as separate entries in the owner's ledger. Property management agreement terminates upon death of owner. Issue: under the property management agreement for the rental of the owner's home, the property manager collects security deposits and rent from tenants. The owner of the home has now died. What is the property manager's responsibility regarding the rent and the security deposits of the tenants? Answer: a property management agreement is a contract for personal services that terminates upon the death of the owner of the home. Upon termination of the property management agreement, the property manager is required to immediately contact the personal representative of the deceased owner's estate and provide any rental agreements, keys, and other documents to the personal representative. CARS, paragraph 32-2173B1. Property management company must be licensed. Facts: a small company manages 5 apartment complexes for one owner. Issue: does the company need to be licensed as a real estate brokerage? Answer: yes. Discussion. Pursuant to Arizona Revised Statutes, paragraph 32-210148. Real estate broker means a person, other than a salesperson, who, for another and for compensation, A. Leases real estate. B. Offers to lease real estate. C. Negotiates or offers, attempts or agrees to negotiate the rental or leasing of real estate. D. Lists or offers, attempts or agrees to list real estate for lease. H. Advertises or holds himself out as being engaged in the business of renting or leasing real estate, or counseling or advising regarding real estate. I. Assists or directs in the procuring of prospects, calculated to result in our leasing or rental of real estate. J. Assists or directs in the negotiation of any transaction calculated or intended to result in the leasing or rental of real estate. Emphasis added. Therefore, the company is conducting real estate activity and is required to be licensed through the Department of Real Estate. Property management company's right to collect rents terminated at the trustee's sale. Facts. The residential property was foreclosed, and the bank took the title by way of a trustee's sale. The tenant occupying the property was not aware of the trustee's sale and continued to pay rent to the prior homeowner's property management company. In fact, the tenant paid 2 months of rent after the trustee's sale to the property management company. Issue. What should the property management company do with the post-trustee's sale rental payments? Answer. Once the lender took the title by way of the trustee's sale, the property management company no longer had a valid property management contract. The property management company should contact the lender, explain the situation, and forward the rental payments to the lender, the new owner,